I'm Bill Barrett. I'm the CEO of Mandelbaum Barrett, and today I'm going to be doing a presentation for you entitled Know Before You Sign. The focus of the presentation is on associate dental agreements and contracts. And I'm going to try to discuss the contracts from both the side of the junior doctor who's being hired, as well as from the side of the practice, so that you have an understanding as you go into these discussions of the different viewpoints or sides to these contracts, which I think is very important. So starting out, I think in the modern era today, people are very reluctant for whatever reason, maybe it's the age of social media, to have meaningful in-person conversations. And it's my recommendation that when you're considering an associate agreement and you've gotten to the point where you've already met with the practice and there's been a dialogue, and now it's time to really get serious about a possible relationship, you have to have a real conversation and talk about the issues that are important to you from both sides of the table. So for example, what are some of the things that should be part of your discussion before you even get to the contract to make sure that you're aligned in your viewpoints? The first thing is understanding, is the practice going to provide mentoring for you if you're the associate? If you're the senior doctor, looking in the mirror and understanding, am I a good mentor? And when I bring a younger person into the practice, what does it look like? What is our approach to their development look like? And talk about the types of cases that they're going to be handling when they initially start. Talk about things like the schedule, the hours, the days. Am I going to be on call for emergencies? Will I receive vacation? How much vacation? Is vacation paid or unpaid? Talk a little bit about the practice and the profile of the patients. Is this a type of practice that you're trying to align yourself with? Is it a fee-for-service practice? Is it a Medicaid-driven practice? Is it a traditional kind of classic fee-for-service combo with PPOs? And think about, what do you want your career to look like, and what type of practice are you trying to affiliate with as you begin your career? What are the expectations on productivity? If you're a senior level doctor and you've been in practice for a while, what you're able to do in terms of cases, the type of production versus what a younger doctor can do is a big difference. And from both sides of the table, there should be an understanding of what are the production expectations. What's the patient volume like in the practice? As an associate, is my schedule going to be filled with patients? Or is this something where you're trying to build the patient volume, almost like the if you build it, they will come concept? Or is the practice already bubbling over with patients where they desperately need the help clinically? And that's a good thing to have an understanding. In terms of future partnership, if that's something you're looking for, have that conversation now. Is the practice looking for an associate that will potentially become a partner down the road? Or is the doctor really not interested in bringing on a partner, and vice versa? Very important thing. Are there expectations on personal origination of patients? Is the practice expecting the young doctor to go out and try to develop patients? Or do they just need them to come in and do the work? Again, all part of a good conversation. Restrictive covenants, which we'll talk more about in greater detail in this presentation. But when it comes to restrictive covenants, what is the practice looking for? What is reasonable in the space and the geography in which you're practicing? Independent contractor versus employee. Is the practice hiring you as an employee, or are they thinking you're an independent contractor? And we're going to talk about the rules governing that in this presentation as well, because that's not something you can just decide on your own. What type of benefits are going to be provided? What's the compensation look like? Are there any thoughts that this practice might be sold someday to a DSO? Is that in the senior doctor's future plans potentially? All really good things that you should be thinking about and conversations that you should have. Have the conversation. That's number one. So let's talk about compensation. Compensation, obviously, very important. Now, typically in a dental practice, you're going to be paid one of two ways. Well, maybe one of three. Some practices might pay you a salary to begin. But for the most part, you're going to see in dental practice contracts either being paid on collection or production. If you're paid on production, as soon as you produce, that's calculated based on a percentage, and then you're paid in the regular payroll. So when you're paid on production, you don't have to worry about necessarily about what's getting collected because you're being paid strictly on what you produce. Versus collection, where the practice waits to see what comes in on the services that you perform and then pays you a percentage accordingly. Now, the first question always is, by everyone, is what's the percentage? What am I going to get paid? Or a senior doctor might say, what's the range that I should be paying somebody? And the answer is it varies, and it varies widely. It varies based on level of experience. It varies based on whether this is general dentistry or if it's specialty. But right now in the marketplace, as of this recording, and we've handled well over 1,000 associate agreements over the last several years all over the country. So we do really get a pretty good sampling of what's out there. And generally speaking, we see about 25% on the really low end to 35% on the high end when it comes to associate compensation, with candidly 30% of collection being probably the most common number that we see in the marketplace. Again, it varies depending on the practice and the profitability of the practice, but that gives you a good sense of the range. When you're talking about compensation, knowing that you're going to be paid on production or collection, some of the things to think about and have a conversation about are the fee schedule. If I'm being paid a percentage of what I do, it's good to know, what is this practice getting for a crown? Because if I, insert a crown for a patient, I need to know and understand what percentage I'm going to receive. And that number could vary widely depending on the quality and caliber of the practice. Is it insurance-based practice or fee for service? If it's insurance-based, what's the realization rate? Again, if I'm getting paid a percentage, I need to know ultimately what dollars are going to come in. Am I going to be paid for exams? If the practice gets paid for an exam and I'm the doctor taking care of the patient, am I going to be paid for that exam? Some practices will say that you're not paid for exams, others will, so that's something to talk about. A big one, are there deductions for lab fees? Am I being paid my percentage on the gross collection or the gross production, or is it on the net after, for example, lab fees? If I'm going with a practice that, for example, has CERAC, and we're going to be doing a lot of things without using a lab, we're going to be doing it internally, is there a charge back at all for the materials involved in producing for CERAC in an office that has same-day dentistry capabilities? Discounts for reimbursed or refunded amounts, that's another factor. So again, understanding, am I being paid on the gross? Am I being paid on the net? What's going to come out of that number if I'm being paid on the net? And also another thought is, am I getting strictly a percentage, or do I get some kind of draw or a base salary and then it's trued up every month after we calculate my production or my collection and the percentage, so that I get maybe a bonus check based on my performance, but a base salary that gets paid in the ordinary payroll. Again, conversations. These are things before the contract is even produced to think about and talk about. Okay, I mentioned before independent contractors versus employees. I find this to be a very interesting thing over the years and I understand why practices will sometimes want to classify somebody as an independent contractor. If I'm on the side of the senior doctor hiring somebody or the practice side of the ledger, I don't have to pay payroll tax if somebody's an independent contractor. I don't have to offer them benefits. So there's certain savings that I might have on the costs of employing somebody. On the other side, if I'm the doctor being hired by the practice, I might like to be classified as an independent contractor because I can offset my income with business expenses and ultimately potentially pay less tax because I have expenses that I'm taking against that gross receipt of income, that 1099 income, being an independent contractor. Well, here's the catch. It's not up to the parties to decide whether that relationship works or not. Whether or not you're an independent contractor and that you qualify to be an independent contractor is based on law. It's based on IRS regulations as well as individual states' Department of Labor regulations. And there's criteria and a test. And the test to determine whether you're truly independent or not is what we call a totality of the circumstances test. It goes into detail to try to dig out whether or not you're truly independent. So what are some of the things they look at? Well, for example, do you work anywhere else except at this practice? Kind of hard to argue you're an independent contractor if you work at one place for one person. That will probably fail, not probably, that will definitely fail scrutiny. If there's an audit and it comes under scrutiny and you work in one location and that's it, you're not an independent contractor. You have to really look at who sets the schedule, who controls how you do things, who covers expenses, all the types of things that go into the analysis to dig into whether you're really independent or not. And remember, there's dual exposure, both IRS as well as state exposure for failure to pay taxes. You can do a whole lecture on independent contractor versus employee, but there are other things like failure to deliver benefits to somebody who's been misclassified. The greatest burden in misclassifying someone as an independent contractor falls on the practice, because most of the laws are designed to really punish the employer for misclassifying. So the burden is on the employer to properly classify. And I always advise my clients to do this the right way and not to gamble or take chances for a host of reasons, not just the taxes, the interest, and the penalties that you will suffer from having misclassified, but I've also seen cases over the years where employees will sometimes use that as a sword later on against a practice when there's a falling out, and all of a sudden they say, oh, well, you've been misclassifying me for the last year or two, and I should have been entitled to benefits, and I should have been entitled to other things that as an employee I would have received, but you deprived me of that. And now they contact the Department of Labor or the IRS, and the employer could have quite a bit of problems on their hands. So very important to properly classify, and in most cases you're going to find that people in dental practice scenarios, in most cases they are generally not independent contractors, they are employees. There are exceptions where someone has their own practice and they're moonlighting in another practice, or there's a specialist who comes to different practices to perform a specialty service, and they're not under the control of the practice. They have their own schedule. There are limited exceptions, but for the most part, you're going to find that people are employees and not independent contractors. Okay. So when you're negotiating these contracts, remember the know before you sign is the title of our lecture today. You got to think about various provisions in the agreement that are important provisions. One of those is termination. So how is it that you can be terminated, or if I'm the owner of the practice, that I'm able to terminate someone that I've hired? And you start to get into conversations about cause versus not for cause. So terminating someone not for cause is kind of like at-will employment. In this case, you have a contract, so it might not necessarily be at will, but you might have a provision that says, hey, I can let you go for any reason, maybe with a certain notice and so forth. But being able to terminate the agreement is something that should be decided and factored into the drafting of the contract. So cause is when you've done something, what I'll call a bad act. So it could be you stole, you were disciplined by the state board, or you lost your license, or you were insubordinate, or you engaged in some conduct that provided a negative impact on the reputation of the practice. Items for cause termination are generally spelled out specifically in the agreement. Now, if I am the associate, I want the definition for cause to be as small as possible. If I am representing the practice and I want to have more flexibility in terminating someone if I need to, I want the definition of cause to be more extensive. And that, again, is the give and take of a negotiation. If I'm the employee, I don't want the employer to be able to terminate me without cause. Or I certainly, if I'm doing something that might rise to the level of cause, maybe I want to have what's called a cure right, an opportunity to fix my bad conduct if it's possible. Okay. So from the associate standpoint, you want to limit the definition of cause. From the practice's standpoint, you probably want to stretch it out a little bit. Other things to consider: if I can't get away as an associate with a not-for-cause termination provision, then maybe I want to say something like, hey, that restrictive covenant that I have, if you terminate me and it's not for cause and you just decide you don't want to keep me anymore, then maybe my restrictive covenant doesn't apply, so that I'm not limited in getting a job elsewhere. That's maybe something you try to negotiate for from the associate side. Or maybe you have a notice requirement that says, yes, you can terminate me without cause, but you have to give me at least 90 days notice. Consequently, if I'm on the practice side of the ledger and somebody has a right to terminate the agreement on the employee side, I'm going to want to ask that employee to give me plenty of notice, because now I've got to go and find a replacement for them. And typically speaking, a practice will want at least 90 days notice if an associate is going to be leaving the practice, and that they agree during that notice period that they're going to continue with their regular schedule and their regular performance, and the practice at least then has some time to find someone to replace them. So termination provision, very important in every contract. Another thing to consider for building into an associate agreement is whether or not there is a partnership track. So if a practice is hoping that someone is going to be part of a future succession plan, or on the flip side, if I'm the associate and I'm hoping that I might have a chance to be a partner in this practice, laying that out or identifying it in the agreement is a good idea. And there's a lot of different ways to attack it. Sometimes it's more what I'll call high level or kind of loose, where it's not really a legally binding provision, but it just basically says the parties agree, for example, upon the first anniversary or the second anniversary of employment, that they're going to have a meaningful conversation about the possibilities of partnership. You're in essence establishing that it's a possibility to be discussed later on. In other deals where either the associate is only joining because they want to be a partner, or the practice is only bringing them on because they're seeking a future partner, you might get a little more detailed. You might establish some criteria in the agreement for getting to partnership, or you might even put what partnership terms would be if the employee is still an employee in good standing. After a certain period of time, there might even be a mechanism that kicks off the process to become a partner. You should identify if it's an option. Think about whether or not if you own the practice, if you've thought about a percentage of the practice that you might be willing to sell, whether the criteria can be established. Is there a timing on valuation? One of the interesting things that always becomes a debate when there's associate buy-ins established in an employment agreement is how and when will the practice be valued? And the age-old argument is always, if I'm the employee, I'm always arguing, well, I'm helping you build the value of the practice and I'm helping you increase the revenue for the practice. So therefore, the valuation should be the day I started, not the day that I buy in, because I'm effectively paying for something that I helped create. That's the associate's argument. When I represent the senior doctor, I always say, well, time out, associate. I'm the person who took the entrepreneurial risk in the first place and hired you to begin with and gave you this opportunity. Why shouldn't I realize some upside on if there is an increased value in my practice? Why should you not pay, in essence, for some of that growth? Because I'm the person that created the opportunity. I'm the founder of the practice. I'm the one that gave you this chance. Why should I not enjoy any of that benefit? And sometimes there's a compromise. Sometimes there's a negotiation of a ceiling or a floor to the valuation. I'm a big believer, if somebody really wants someone to be a partner and they're structuring one of these agreements, to talk about these issues, to talk about dates. If there's going to be a valuation at some point, when would it be valued? And is there a formula? Could we agree on a formula right now on how the practice will be valued? So there's a lot of discussion that can take place over the issue of partnership track. I also, in all employment arrangements, but particularly when someone might become a partner, set up monitoring or benchmarking or reviews to talk about, are they on track for this partnership opportunity? Are they hitting the benchmarks that you would expect one to hit? And another way to, create criteria for being a partner in a practice, if you know that you don't want to make someone a partner until they hit a certain level of production or collection, establish that in your terms if you want up front. So partnership track, another very important thing to consider. So now everybody's favorite, restrictive covenants. Restrictive covenants, often when people say the word restrictive covenant even, their mind immediately goes to non-compete. The term restrictive covenant isn't just about non-competes. It's talking about restrictions on your employment and what you can do in general. So some of those things, for example, are confidentiality. Confidentiality can be in an agreement as a restriction, meaning that you cannot share certain information or things that you learn while at the practice with anyone outside of the practice. There's also non-solicitation. Non-solicitation means that when I leave the practice for whatever reason, I'm not going to solicit a patient to join me elsewhere. I'm not going to solicit a staff member to join me elsewhere. Or maybe if I'm a specialist, I'm not going to solicit a referral source to refer to me elsewhere. That's solicitation. Non-compete, which is the one everyone thinks of, that means that for a certain period of time within a certain geography, you're not going to allow someone to practice dentistry or whatever their specialty is. That's taking someone out of a marketplace. And in some states, most noteworthy, California has for a long time has in strict employment situations doesn't allow non-competes. They allow non-solicitation and confidentiality, but not non-compete. But in most states, a non-compete is not only permissible, it's enforceable, provided that it's reasonably limited in time and geography. So what does that mean? It means you can't have an associate employee and say, oh yeah, you have a restrictive covenant for 5 years, you can't work within 20 miles of any of my offices, because a court is likely to say, that's over the top. People have a right to work, and while you also have a right to a restrictive covenant or a non-compete, to put somebody out of a marketplace completely for 5 years when they're not an owner of the business, they're just an employee of the business, is probably going to be determined by most courts to be an overreach. So what is reasonable on a non-compete restrictive covenant? It depends. On the timing side, when I represent a practice, I generally encourage them to not have more than a 1-year non-compete. And when I represent an associate, I generally will tell them that they shouldn't agree to any more than a 1-year non-compete. And my experience is that when it comes to the time side of the ledger, a 1-year non-compete typically will be enforced. It's not overreaching to put somebody out of a market in states that allow it for 1 year. When it comes, that's the time side of what has to be reasonable. The geography side of what's reasonable depends on where you are in the country. Are you in a city? Are you in suburbia? Are you in a rural area? And a lot of times it's looked at from a basis of population density and, in essence, how far will people travel to see their dentist or their dental specialist. So if I'm in New York City, a reasonable geography for restriction might be a series of square blocks. It might be just a neighborhood. It might be just one little portion. If, let's say, it's Manhattan, it might be, I can't compete in Tribeca where the practice is located, or I can't compete in, this particular, set of square blocks, a couple of blocks to the north, to the south, to the east, and the west. So that's a heavy, densely populated city restriction. If you were to say, you can't practice on the island of Manhattan in New York City, and that would probably, under all circumstances, be thrown out because it's just it's too broad in terms of its geography. But now, come outside of a city area to the suburbs is when you start seeing 5 and 7 and sometimes 10-mile restrictions being reasonable. And then when you get further away into rural areas where people might have to drive 20 miles to go see a dentist or a dental specialist, that now becomes reasonable. So remember, there's different types of restrictive covenants: confidentiality, non-solicitation, which is always going to be upheld, and non-competes, which will be upheld provided that they're reasonably limited in time and geography. I'll often hear people say, oh, well, it doesn't matter what I sign because those things aren't enforceable anyway. Not only are they enforceable, but case law in most states will show you that doctors have an imputed level of sophistication that courts have imputed to doctors based on their education level, that they understand the issue of a restrictive covenant, and that they're more inclined actually to enforce a restriction against a doctor than they would, for example, a salesperson in a general business. So, understand that not only are these things enforceable, but you as a doctor are going to be imputed a higher level of intelligence and sophistication. Whether it's deserved or not is subject for debate another time, but that's what the courts are going to do. Another thing to think about when it comes to restrictions is maybe some carve-outs. So what's a carve-out? A carve-out is to say, okay, I hear you, I agree to this restrictive covenant that you've put in here, but I would like it to not apply to patients that I bring into the practice myself, that are identified as my patients. Or if I'm a specialist, if I build a relationship with a referral source that has become my referral source that wasn't referring to the practice prior, it's not unreasonable to try to negotiate that your patients and your referral sources will not be subject to the restrictive covenant. One last point I'll make on restrictive covenants, just to kind of close the loop, is there's a big difference between an employment relationship and a sale of a business. See, courts will recognize that in the sale of a business where goodwill is transferring and significant dollars are being paid for an asset, courts will regularly recognize longer, broader, deeper restrictive covenants as appropriate and enforceable because it's in the context of the sale of a business, which is very different from an employment relationship where courts want to be very cautious and on how they enforce that restriction because of the right to work. So remember, they always have to be reasonable for a court to enforce. That's restrictive covenants, very important in every contract. Okay, so I think that gives you a lot of information on the things you need to be talking about when you're going to enter into an associate agreement, some of the key provisions and terms that you should be reviewing and negotiating carefully. And obviously, at the risk of being self-serving, you should have representation. You must have a lawyer with experience in dental contracts represent you, whether you're the practice preparing the agreement or you're the associate considering entering into the agreement. You should have representation so that you can get the right guidance and the right negotiation. But for those of you who maybe already are in practice or associating somewhere, or you've decided that maybe associating isn't for you and that you want to have your own practice and you want to do it early in your career, you would be what I call a dentrepreneur, for lack of a better word. And one of the pieces of advice I'll give you, we could do a whole nother lecture on buying practices and starting practices up and so forth, but a couple of important things. If you happen to be an entrepreneurial dentist that wants to have their own practice, start by assembling your team. I would like to describe it as assembling your own mini board of directors to help guide you through your career, not just through one acquisition. You want to have a relationship with your advisors that's transformational and not transactional. And I'm going to hammer those words home again. Transformational relationships versus transactional. I always know that somebody is a transactional person when they call me up about a possible representation, and whether you're a lawyer, an accountant, or any other type of professional, and before they've even described the type of transaction, they ask you how much to do this. They don't know anything about you except that you might be qualified, but they haven't even described what they're trying to do. You haven't had a chance to even learn about their goals, what their ideal outcome is, and it's strictly based on a price. That's a person whose mindset is transactional. Transformational is somebody who wants to have deep, great relationships with a team of advisors that they can rely on, that they know are the best in class in terms of their services, but also people that they have a chemistry with, which is very important. Talent alone isn't good enough. You have to have chemistry with the people who are going to be your advisors. So not only should you have a great dental-specific attorney that's going to represent you, but you got to have a great accountant. And by the way, as you build your practice, always remember you want to hire professionals where there is room to grow together. So I never want to be the biggest client that somebody has, right? I don't want to find out that as I'm building my dental empire that I'm the single biggest client that my accountant has. I want to know that my accountant has some unbelievably successful fellow professionals that they have experience with, who have done the things that I want to do or that I dream of doing, and that they've been side by side with professionals, because they can provide me a lot better guidance and knowledge because they've been part of the success that I'm trying to accomplish. So ask a lot of questions when you interview people. Get to know them. Meet up with them. See if the chemistry is there. Make sure they've got the skill sets. Make sure they have clients that are already successful doing what it is you want to do. So you've got your attorney. You've got your accountant. I mentioned banker. Why do you need a banker? Access to capital, number one. But throughout your career, whether you're going to buy a practice, buy another practice, build the practice out, maybe a startup, or maybe you want to buy the real estate where your practice is located. If you have a great relationship with a bank and a banker, on your cell phone, you can call and get their cell phone and say, hey, it's so-and-so, and they know exactly who you are and you have a relationship. That's powerful. Financial advisor and benefits advisor. Again, people with specific knowledge in your profession who will have programs or platforms that are specific to you that will be to your benefit. I'll talk a lot of times about how you should hire insurance professionals that have experience in your profession, because not only do they have a lot of knowledge, but they have access to markets, okay? So this would be like underwriters of insurance who have programs specifically built for you and for your profession. Whereas I might go to someone who's not in the profession and they might have relationships with underwriters that don't have special programs that I could have access to. So financial advisor, benefits advisor, practice broker, your insurance professional, and my last one is a practice management specialist. A practice management specialist is powerful because they will help you on the business side of things, building out your systems, helping you build the culture of your office. Remember, culture will eat strategy for breakfast all day long, okay? Culture is very important, and practice management specialists that are top-notch will not only help you run a better business and build a better business, to help you build a better culture. So assemble your team when you're going to be a dentrepreneur. Assemble your team, and it will benefit you greatly throughout your career. So the next thing I want to talk about, again in this segment for folks that want to go and own their own practice right away, is how am I going to find one? And there's a few different ways, right? A cold introduction is kind of what I'll call a letter writing campaign, trying to identify practices in a geography that you're interested in, where it's a right fit for you, and maybe you've found practices where the doctor that owns the practice might be in the twilight of their career, or they may be nearing or getting towards transition age, where they might get a letter from you or a phone call from you, and that might kind of strike a chord with them and create an opportunity for you to talk about whether or not they might be interested in selling their practice. That's a great thing too, because if it works out, you're kind of hand picking or hand selecting what you're looking for. You may be potentially saving money for the seller. So, cold introductions do work sometimes. Warm introductions are terrific, where somebody has introduced you, or you know somebody, or you feel comfortable enough to call somebody and say, hey, I'm so-and-so. This is what I'm looking for. I'm wondering whether or not you might have time to have a cup of coffee with me, or grab a lunch and talk about the future, because I'm very interested in being a practitioner in the same marketplace that you're currently in. That's the warm introduction. And the last one is third parties. Now, right away, third parties, you think brokers, which is great. Getting a great practice broker that's on your side, that's out trying to help find practices for you, is terrific, and they can be incredibly valuable. And I recommend brokers all the time. But don't forget, remember, you've assembled that team of dental-specific professionals that can really help you. They're going to have a lot of relationships with doctors. They're going to know a lot of doctors, and they're going to also have relationships where they may be one of the first phone calls from someone who's considering a transition. So a dental-specific lawyer or accountant or financial advisor or insurance professional and so on, practice management expert, in addition to brokers, they could be great sources of introductions for you for a possible practice acquisition. So these are just some ways that you might go about finding that first practice for yourself. So I really want to thank you for your time. I hope that you found Know Before You Sign to be a valuable exercise and good content for you. Feel free to give me a call anytime if you want to reach out for me or shoot me an email. I'm very happy to help give you some guidance as you consider entering into an associate dental employment agreement or preparing an associate dental employment agreement for a future employee of your practice. So thank you very much for your time, and it was my pleasure to speak with you about this subject.